Welcome to the Scaringi Law Lunch Break. This is your time of the day to learn a little bit about the law while you enjoy your lunch. An important Second Amendment right to possess firearms case was decided just a few weeks ago in the United States District Court for the Middle District of Pennsylvania. In the case Holloway v. Sessions, the court ruled that Mr. Holloway, a two-time DUI offender, is entitled to have his right to keep and bear arms restored. This is a wonderful outcome for the Second Amendment. From 2002 to 2004, Mr. Holloway received 2 DUIs. The first was handled through Accelerated Rehabilitative Disposition, otherwise known as ARD. Mr. Holloway successfully completed ARD, and as a result, his DUI offense was expunged. However, although an ARD expunges one's first offense DUI, it still counts against you for second and subsequent offense DUIs. So when Mr. Holloway was charged again, he was looking at a second offense DUI because his ARD was considered his first offense. Because the second offense DUI was at the highest rate of blood alcohol concentration level, that put Mr. Holloway in the third and highest tier. That means his second DUI was graded as a misdemeanor of the first degree. Because of the grading of that offense, he's now a prohibited offender. He's prohibited to possess firearms under the Federal Gun Control Act of 1968, which prohibits felons from possessing firearms. Interestingly, he's not prohibited under Pennsylvania state law, only under federal law. This federal act defines as a felony any state misdemeanor offense that carries a maximum period of incarceration of more than 2 years. The maximum period of incarceration for a misdemeanor of the first degree in Pennsylvania is 5 years. So, under federal law, a misdemeanor of the first degree in Pennsylvania is a felony. How about that for Orwellian logic? But that's the law. So Mr. Holloway filed a lawsuit in federal court challenging the constitutionality of the Federal Gun Control Act as applied to him. He maintains that his DUI conviction should not deprive him of his Second Amendment right to keep and bear arms. Mr. Holloway is proceeding under a couple of trailblazing cases known as Marzarella and Binderup. In those cases, federal courts have promulgated a two-step analysis judges will utilize when considering whether to restore Second Amendment rights of a prohibited offender. The first question is whether the offense is a serious offense. If it's a serious offense, the person's Second Amendment rights will not be restored. If the court determines the offense is not a serious offense, it will move on to step 2. You have the burden of proof as the person requesting to have your firearms rights restored. The court has come up with a list of 4 factors to determine whether the offense is serious. Now, it's not an exclusive list, but here they are. 1, whether the state classifies the offense as a felony or a misdemeanor. 2, whether the offense has actual or attempted violence as an element. 3, the severity of the sentence actually imposed. And 4, whether there is cross-jurisdictional consensus on the seriousness of the offense. So, if your prohibitive offense, like Mr. Holloway's second offense DUI, 1, is a misdemeanor, 2, did not involve violence, 3, the sentence received was light or on the low end of the sentencing range, and 4, there is no consensus among the states that your offense is severe, or the consensus among the states is that your offense is not severe, then, like Mr. Holloway, you're a good candidate to have your rights restored. And in fact, Mr. Holloway did have his rights restored. That's because step 2 of the analysis, the burden is on the government. And here's the second part. Here's step 2. The government has the burden to prove the statutory prohibition of your Second Amendment rights constitutes a substantial fit between your disarmament and the government's interest in preventing armed mayhem. The standard also requires some meaningful evidence, not just mere assertions, to substantiate the government's position. So the government needs to prove with meaningful evidence that it needs to keep you disarmed to prevent armed mayhem. That's got to be a pretty tough standard for the government to satisfy, and it turned out to be too tough for the government to satisfy in the Holloway case. So if your underlying prohibitive offense did not involve violence, And if your conduct since that offense has been good and has not included subsequent criminal convictions or actions involving violence, you're a good candidate to have your Second Amendment rights to keep and bear firearms restored. If you win Steps 1 and Steps 2, you win back your right to possess firearms, notwithstanding the fact you're convicted of an offense that disqualifies you under the Federal Gun Control Act. The judge's decision will state the act does not apply to you. This is the quickest way to have your Second Amendment rights restored after being convicted of a disqualifying offense. A pardon is another option, but that could take 3 to 5 years. If you're convicted of a nonviolent misdemeanor of the first-degree offense in Pennsylvania and would like to have your Second Amendment rights restored, you have that opportunity now under federal law. Give us a call at 717-657-7770. We'll explain the process to you and discuss the merits of your case. That's about all the time we have today for the Scarinci Law Lunch Break. I hope you learned something about the law. Enjoy your lunch.